Welcome to Leyes Cotidianas, or Everyday Law, where we discuss the laws that affect you every day. Today, we will be discussing foreclosures. What happens when you may not be able to make the mortgage payment? What options are available to you? Do you have the ability to modify your loan? Do you have the ability simply to try to work it out with the lender? These are all of the kinds of questions that we will be discussing today, and we hope that you join us later on Leyes Cotidianas. Leyes Cotidianas. Today we will be discussing foreclosures and what to do if you may be faced with a foreclosure. We have with us today two guests. Our first guest is Jim Fletcher. Jim Fletcher is with the Guerin Law Firm. Jim represents lenders and has recently published a book, Georgia Confirmation Law. Welcome.
Good morning.
We also have with us Ryan Strickland. Ryan Strickland is an attorney in Atlanta. He is a partner with the law firm Evans & Strickland. And Ryan primarily represents individuals who may be facing default and facing foreclosures. Thank you for joining us.
Thank you for having me.
All right. I think perhaps the best place to start, I know folks have understood foreclosures and understood the general concept of it, but they may not realize really what the process is before you actually face a foreclosure. And I think perhaps the best way to start would be maybe to start with you, Jim. If you could walk us through what are the things that happen that lead up to foreclosure. I mean, if you're a few days late on a payment, it doesn't necessarily mean you're going to be facing foreclosure, or does it? And if so, if you can just walk us through the whole process.
That's right. And the good news is that throughout the entire process, there are programs that are in place that we will talk about later that you can try to resolve any problems that you're having with the lender. Early on, if a payment is missed, there's going to be communications that will be coming from the lender. There may be letters, there may be telephone calls, and the important thing at that stage is to communicate with your lender. What will then happen is, depending on the terms of your particular mortgage note, and there may be some other legal documents that are involved, one is called a security deed, there will be some requirements imposed upon the lender. One of those requirements is sometimes we call it a pre-acceleration letter. Generally speaking, what that means is, as a borrower, you have a right to only make payments as you go along. If you have borrowed $200,000 on a house, you do not owe that entire $200,000 today. You have the right to make payments. But
so what do you mean when you say pre-acceleration? What does that mean?
Sure. What that means is if payments are missed, and there's several payments that are missed, then the lender may have the right to require the entire balance of the loan to be paid all at once. And we call that accelerating the debt. Instead of owing it over 30 years, it would all of a sudden be owed immediately.
Due now.
It would be due now.
Okay.
And once it is due now is when the lender is able to put the property into foreclosure. They have to accelerate the debt.
Okay. But before they can do that, you said that there are some letters and so forth that are received. So there may be a phone call from the lender, obviously saying you're a little bit late.
Exactly.
Then you're going to get some kind of a certified letter, I assume? Is that?
Generally speaking, the letter will be a 10-day letter, which says you have 10 days to bring the note current. And if you do not, at that point, then the lender has the right to, as we said, accelerate the debt.
Okay.
and make it due all at once. Again, there's a series of good news. Under a very common form of loan document, even though the loan gets accelerated up until 5 days before the foreclosure happens, the borrower still has the right to catch up and just pay the late payments, and if there's some fees have accrued, to pay those, and without paying the entire debt that was accelerated.
Okay.
So that's one of the first steps, is that there will be these early communications and then a pre-acceleration letter.
Okay. And this entire process, just to give folks a sense of how long are we talking about? Is it a week? You said 10 days. What's sort of the soup to nuts time
Sure.
frame?
It really depends on what particular state you're in and the lender in particular.
Okay.
A motivated lender, it is possible that in as short as 2 months, the process could happen. It's really more common to see it take half a year, or sometimes as long as a year, because the lenders will make multiple attempts to try to resolve the issues. You know, as many as 1 out of every 200 houses, it's being estimated, may go into foreclosure. And make no mistake, the lenders do not make money on the foreclosure process.
Okay.
In fact, they tend to lose sometimes as much as 40 to 60 cents on the dollar on a house that goes into foreclosure.
So there's some incentive there for the lender to do something to at least try to work through this with their customer. Is that fair?
That's exactly right.
Okay. All right. Well, it sounds like there's a couple of things that happen initially. Ryan, let me turn it over to you. Let's assume for the sake of argument that the foreclosure process is starting, the pre-acceleration letter has been sent, and correct me if I'm wrong, but I think the next step at that point then is to start potentially advertising it for sale. Is that the next step?
Well, there's depending on what state you're in,
Okay.
it is going to determine what the next step is. I think the important thing for a borrower at that stage where they know that they're getting behind or they have gotten behind for the first or second time, that's the point where they need to start taking action.
And what do you mean? What kind of action would they take at this point?
2 things, really. Number 1, consulting with a professional in whatever state they're in, an attorney, and possibly the attorney might actually refer you to an accountant or other tax professional, because there can be tax consequences that can cost a homeowner a lot of money in this process. The other option, or the other thing that the homeowner needs to do, is also reach out to their lender.
Okay.
Because all of these foreclosure alternatives or options that Jim mentioned are only available if the homeowner reaches out to their lender. In the clients that I see coming into my practice and that I deal with, I've noticed a pattern that a lot of times people are scared in this process, and when they let that fear of what's going to happen take control of their judgment, that doesn't lead to good results. Sometimes it leads people to not take any action at all.
Okay.
And not taking any action is probably the worst thing you can do in this process.
Well, it sounds like, I mean, from what you're describing, is that because the process is, number one, regulated, and there are certain steps that have to be taken, each one of those steps provides an opportunity. It's an unfortunate situation, but at least there's an opportunity. We talked about, obviously it starts out, you can't pay. There you get some collection efforts that are being made. You get a letter, and it starts to escalate at this point. You get a letter saying, now not only are your regular payments due, but now the whole thing may be due at this time. What exactly is the next step? We didn't quite get there. What's the next step once it looks like you're not doing anything at this point? If you keep quiet, which is not a good option, what unfortunately happens next?
Okay. There are 2 different types of processes that happen. Some states require the court to be involved to actually handle a foreclosure.
Okay.
In some states, for example, in Georgia, we do not require a court. It's optional to have a judicial foreclosure or a non-judicial, meaning without the court foreclosure.
Okay. So you're saying that the bank could go ahead with the foreclosure process and not have to step foot in a courtroom, not have to get a judge involved, not have to do anything. They really can just go through the process and actually foreclose without ever having to create litigation around it.
That's right, and that's
Okay.
true in Georgia. And in Georgia, we have a process where 30 days before the intended sale, the lender will send a notice of the sale to the borrower, letting them know that 30 days or more from now, there will be a sale, telling them what the property is being sold, the date and time of the sale, where it will be, and additional information. At the same time, the lender will have to do a public notice, an advertisement in the legal ads of the newspaper, and in those ads, it will let the public know, and most importantly, investors who might be interested in bidding on the property. Because what the point of the process of selling it is, if the borrower is not going to repay the debt, then it gives the lender an opportunity to at least mitigate their loss and get something back on the loan and potentially get the property back in the hands of someone who will take care of it.
Okay.
After that advertisement period and the notice period has gone by, then there is a public auction. In Georgia, we literally do it on the steps of the courthouse. And so on the first Tuesday of each month, unless it's January where you have New Year's might conflict, or July 4th holiday where it would go to the next Wednesday. But on the first Tuesday of the month, there will be a public auction, and someone will, as they say, cry out the sale. Hear ye, we're selling this property. And frequently other people will come and bid on the property. They generally need cash or certified funds in order to be able to buy it. And very commonly, though, the bank will end up buying the property itself. The bank can bid on the property and buy it, and then the property may get sold through a real estate sales department and marketed to finally sell it through more of a retail sales channel.
Okay. So, Ryan, let me throw it back to you. With regard to issues that may come up in this process, if a borrower comes to you and they've received these various notices and it's being advertised and so forth, is there, other than seeing if they can work it out, are there any defenses that they may have to a foreclosure?
Absolutely.
There's, one thing they could work it out, and we'll talk about some of those options in a minute, but, do they just have straight up defenses, this foreclosure can't go forward, and here are some legal reasons why? Can you give us some examples of that?
Absolutely. The reason that the lender has to send out these notices is because the homeowner has rights in this situation. That's something that's a very common misconception, that many people think that if you just miss your mortgage payments, then the bank automatically has a right to come and seize your home. It's not that straightforward, it's not that clear cut, and the homeowner does have rights in this situation. Those rights differ from state to state, so obviously contacting an attorney in the state where your home is located or where you live is the best course of action. But generally, those rights include a right to proper notice that this foreclosure sale is going to occur. In states like Georgia, where it's a non-judicial foreclosure state, that notice is extremely important because it is the last communication between the lender and the homeowner before the homeowner takes possession of the home legally at the foreclosure sale, because there's not going to be a court action in a non-judicial foreclosure state. They're, just like Jim said, they're just going to show up on the courthouse steps and auction it off. So,
Let's do this. Let's take a break right there, and then we'll come back and go through some of the other defenses that you may have. Thank you.
Desde el momento en que ellos llegan a nuestras vidas, dan su primer paso, aprenden a andar en bicicleta. Hasta la preparación de su primer día del 5º grado es un reto para todos los padres criar un hijo saludable. Permítanos guiarle a través de un embarazo seguro y feliz. Aprenda sobre salud, nutrición e información educativa relacionada con el desarrollo de su hijo. Padres e Hijos Atlanta, una publicación del mundo hispánico. Recoja su copia gratis hoy. ¿Cuál es su tesoro más preciado?
Welcome to Leia's Code to Dionys. Today we're talking about foreclosures. Before we took the break, we were talking about some defenses that a homeowner may have. Just because the foreclosure process started, there are some defenses that can be raised. You had mentioned a few with regard to the notice and how the notice was given. Are there any other defenses that a homeowner may have to the foreclosure process?
generally, yes. And this obviously depends on, again, what state the property is located in and what state the homeowner is residing in. But generally, there are also, most states recognize that a homeowner has a right to a correct accounting of their payments by the lender or the servicing company that is handling their mortgage. For instance, if for whatever reason, through typo or clerical error, their payments are being misapplied, then the homeowner has a right to address that with their lender. What the process by which they address that with their lender is going to depend on what state they reside in. Okay. And another thing that generally most states recognize is that a homeowner has a right to rely on what the borrower, what the lender's representatives say to them on the phone. Any representation they make about the fact that, for instance, a short sale has been approved or that a foreclosure is being postponed, most states would recognize that a borrower is entitled to rely on that information.
Okay, so if they are having discussions with the lender and taking, in essence, the advice that you all are giving, which is start talking and making sure that you're having open communications, if they're getting good feedback from the lender that it's fine, we're not going to go forward, and it's still going forward, is that sort of a left-hand, right-hand situation at the lender? Is that what's going on, or it's not being communicated to the right folks?
One point that I would make on that is that it is with relying on things that the lenders say. If you start to see events which are inconsistent with what you believed was going to happen, if you were told that there was going to be a modification and now all of a sudden you're receiving a foreclosure notice in the mail, at that point that's a red flag that either something has changed, something didn't get approved, you misunderstood, or as you mentioned, there may have been one of those left hand not knowing what the right hand is doing type things. At that point, it's important to communicate with your lender. If that is unsuccessful, then do speak with a professional, whether it's an attorney, there's certified credit counselors who can maybe help resolve what's going on. But don't just assume and disregard the notices.
I was just going to say, it seems like the last thing to do would just be say, oh, well, obviously the paperwork's incorrect. I'm sure it'll be fine.
Right.
You need to double check that and make sure. We talked a little bit at the beginning about that you may have some options. You've clearly got some defenses that can be raised if it's not done correctly and so forth, and some options. And it looks like from what you're describing that the lenders do have some incentive to explore these various options with folks. Can you give us an idea of some of the options that people may just not realize, other than can you work with me on my payments? Is there some other options that are available that folks might have if they're faced with this situation?
Absolutely. There are a slew of formalized modification programs. Some of those are federally mandated and managed. Others will come directly from your lender that will be an in-house type of modification program. What a modification means is when you first borrow money to purchase a piece of property, there are going to be certain terms that are involved. An interest rate, an amount of principal that is borrowed, a repayment term. The classic is the 30-year fixed rate mortgage. But during the last several decades, there have been other products, adjustable rate mortgages and balloon interest rates and things like that. In a modification program, and I'm going to take, for example, the HAMP program. That's the Home Affordable Modification Program. In HAMP, if it appears that the payment, the monthly mortgage payment, including additional items such as escrow items, insurance, exceeds 31% of the borrower's gross monthly income, then at that point it becomes unaffordable. And many people are not able to make that type of payment. And so we want to see if we can bring the payment down to the 31% range, which is more affordable.
So that's sort of like the threshold. If they're looking at the numbers and they're saying with the adjustable rate and so forth now with rates are obviously a little low right now, but as
Right.
if they pop up, that if it puts you in a percentage where you're over 31% of your actual income, no one can really afford that. Is that the concept?
That's the
assuming
concept.
all of the other normal.
Is that many people cannot afford that given other, on average.
Right.
Therefore, there are several ways to make that more affordable.
Okay.
In these modifications, almost all of them involve a reduction in the interest rate. So there's less interest being paid. It may be, maybe stretch out the term. Instead of, if there's 15 years left, well, if we stretch the payments out, then we can make the payments themselves lower. In very few instances, the principal itself may be reduced, but there are some principal reduction modification programs that will reduce the principal itself. As a statistic, that can be a reduction in your payment of up to 40%, which can be very significant. To get into a modification, you have to apply. So you have to reach out to your lender, apply for the modification. There will then be an evaluation of whether or not you meet some basic qualifications that go into that particular program. Sometimes there will be a trial period of 3 to 4 months to make sure that can you even make these reduced payments. If you've been, some people stop making payments and they say, well, I could make a lower one. Can you make lower payments? And then see if you are eligible to have your loan permanently modified. More than 2/3 of eligible persons who are eligible for modification at all end up with a permanent modification. So that's what I said, that there is hope out there. That's one of those areas that can provide hope.
Let me do this. I've heard a lot about this concept of what's called strategic default. And strategic default, my understanding of it, and hopefully, Ryan, let me turn it back to you. Can you explain to us strategic default? People often say, I owe so much more on this home than it's worth, either because they bought it at a high market and it's just the market has gone down and they don't really, the house isn't worth that much. And they're considering their options and they think, I'm never going to pay this mortgage off. This house is never going to bring this. Maybe I'll just walk away. You hear this is sort of things that people are talking about. Can you tell us, number one, whether that, I mean, it sounds rosy, I'll just walk away from my obligation. Is that really an option? And then what are sort of the considerations that one might have in looking at that?
In most states, it's not nearly that easy.
Okay.
This is an important point, is a lot of people turn to resources like the internet to find out information about this. The thing to keep in mind is information on the internet oftentimes is not entirely accurate, or it may be accurate for a state that's not your state. So the important thing to remember here is when you're thinking about strategic default, or you're in a situation where you owe so much more on your home than you think it's worth, or your payments are so large that you can't afford them, that you really need to consult with a professional in your state to tell you what the laws are in your state about these various options, foreclosure or foreclosure alternatives. And that a professional in your state can guide you as to whether you have a claim, number one, about any sort of documentation problem. The internet is actually a good source of a lot of the information out there about documentation. Not all of it is entirely correct. And a homeowner should never just rely on something that they've read on the internet. And again, a professional in your state can tell you what is correct and what's not.
What would be some of the things, let me, Jim, maybe if you can add, what would be some of the things that you would consider if you were going to go ahead and go forward with strategic default, or either one? Strategic default, can you just get away with it, or would there be other things that you would need to consider with doing that?
Sure. There are going to be several impacts that a foreclosure is going to have on a borrower. One is there's going to be impact on their credit. Another is going to be the risk that the foreclosure sale itself, that public auction, does not satisfy the debt that was remaining on the loan. So take a very basic example. If you still owe $100,000 to the bank, and at the foreclosure sale the property sells for $60,000, then there's going to be a deficiency, a gap of $40,000 plus some collection costs. They're going to be, the cost of the foreclosure and some attorney's fees, et cetera. So there's going to be this amount of money left. If the bank decides to try to collect that, then they may obtain a judgment against you. There may be collection efforts, and so there may be some effects that has on that remaining debt. And sometimes one of the only ways to avoid that debt permanently is through a bankruptcy type of process. But not all persons are eligible for bankruptcy, and there may be some repayment obligations even in a bankruptcy plan.
All right. Brian, let me ask you this. I've also heard this term, and folks hear this, robo-signing. What does that mean quickly, and if you could give us a sense of that? And then if there's one thing that you would convey to someone who is looking at this, what would that be? What would be the best advice you would give them?
Sure. Robo-signing generally means that a lender is using an outside company to complete all the signatures or the compilation of the paperwork necessary to actually foreclose on someone's home. Okay. And there are different ways that they can go about doing that. This is another source of a lot of controversy on the internet. There have been programs about this on major news outlets. It means different things in every state in terms of whether you may or may not have a claim. For instance, in Georgia, a lot of these robo-signing claims are not going to give you a cause of action or a claim against your lender under Georgia law, but it may in another state. And that gets to your question of what's the most important thing. And the most important thing is to reach out to a professional in this area to help you, and reach out to them early in the process.
All right. Well, thank you both very much for joining us. I appreciate it. I think we have a much better understanding of foreclosure, the process, and then also what we need to do and what options you might have if someone is facing that circumstance. If you would like to have more information, please join us on leyescotidianas.com. Thank you so much.
Leyes Cotidianas les llega a ustedes gracias al generoso apoyo financiero de la Fundación de Justicia Civil del Estado de Georgia. Mundo Hispánico, el vocero de la comunidad hispana desde 1979. La estación transmisora WPBA no tiene licencia para practicar leyes en el estado de Georgia. WPBA y los patrocinadores de este programa no son responsables por las opiniones expresadas ni la información proporcionada por los abogados en este programa. Este programa se ofrece como un servicio público. El objetivo de este programa es de informar y educar y no de proveer consejo legal. Si usted necesita consejo legal, favor de consultar a un abogado.